they doing while all this was going on?
A good question.
And did they have a duty to pay attention to what was actually being sold? Did they have a duty to investigate? Is there something of value in this package, and how is it being created? I mean, this seems like there's a whole web of intrigue related to this.
There's a whole web, and it's pointing fingers who had the responsibility of monitoring this type of securities. Were the exchanges? Were the people underwriting the securities? Were the people creating the securities? How was the disclosure being done? So who really understood what all of these securities were all about?
Do they understand today?
I don't think they understand 100% of them.
Okay, well, we are where we are, and my understanding is that some of these banks who are involved in these foreclosures now did something, these Robo signings, and some individuals were signing affidavits as much as 10,000 affidavits a month, saying they've gone through these foreclosure documents. What happened there?
Here's what happened. As more and more foreclosures came into play, more and more defaults came into play, banks started automating the process and looking through their system and just plugging and playing information without doing the due diligence on who owns the mortgage, where the mortgage is, who are the actual owners, where was it recorded, where's the name spelled correctly, and it requires a whole review of actually the foreclosure.
But Thomas, this is a legal process. This isn't about somebody that may, you know, have a junior college education being in charge of documentation and that they're pressing the button and then it processes. Who is actually minding that process to ensure that legally the correct people were having their homes foreclosed on, that the people that were foreclosing actually owned the asset they're trying to foreclose? Who was monitoring that?
I think that they were pretty much aware of who owned the asset. Yeah, we've heard some side stories of houses being foreclosed by people who didn't own the asset and so on. Yes, but more of what I think Mark is referring is this robo signing, where there's a lot of errors. A couple of the banks reported 100,000 corrections taking place immediately. Another bank today reported another 50-some thousand corrections taking place. But the focus really is trying to push it through the system and get it done. Imagine 10,000 loans. How long does it take each package to foreclose? How many resources you need to do so?
My understanding is in some cases, if someone stops paying their mortgage, and let's say, for instance, that property, that residential property is underwater. In other words, the loan is more than the market value, and the bank's not in a particular rush to foreclose on this thing, people might wait 18 months before they actually have to leave the house after they stop making their mortgage payments, and these robo-signing things might even extend that time.
Right now, the average is, like you say, is about 18 months, but it's not that easy. Even if a bank forecloses on the property and sells it to a third party, you still have to be evicted. That's still an additional procedure that has to come through the process. And it takes time for the process. You first get, first, if you don't pay your mortgage, you'll probably get a call from the bank and say, hey, you forgot to pay your mortgage. The next step is the bank will go and file a default notice with you, and then they'll start a foreclosure process. But their backlogs is such great that it's taking 18 months. But once they foreclose, doesn't mean that you're out of the house. They still have to evict you. And that takes an additional move.
Well, you know, Mark, I think that this subject needs to be revisited again. And Thomas, I wanted to let you know that you've just brought a whole new light into this that I think a lot of people don't realize when they see the headlines. But I think today what we have to do is we have to kind of bring this segment to a close. And we invite you to stay for our next segment. Are you willing to stay with us?
Definitely.
Okay, so I think I will tell you, Mark, this is an exciting subject.
And it's complex, and I think everyone's interested in how it all worked out.
And so at this point, I think we're going to move over to our constitutional corner. And Mark, I think we ought to move forward. What are we covering tonight?
Well, we've been looking at some constitutional issues about the Commerce Clause lately, and what happened is what they call Obamacare has said, look, if you don't buy insurance, health insurance, then you can be fined. And they said, we're going to do this under the Commerce Clause. And we talked previously about before, citizens have been prohibited from doing things under the Commerce Clause, but under the Constitution in this country, no one has ever been commanded or forced to do something under the Commerce Clause. So this is a new precedent. And right now it's in federal courts, in several different federal courts.
Well, how many is it? Are you talking about states that are bringing it to court, or are we talking? I know we've touched on this before. Is it states that are bringing it, or individuals that are bringing it? Who's actually bringing this to the federal courts?
To the largest extent, it's state attorney generals who are bringing it, but it's coming in different angles. Now, Virginia is a little different than the other states because they actually passed a law 14 days before Obamacare was passed by the federal government. So they actually have a law that says people can't be forced to buy insurance. So we have almost a 10th Amendment situation there with states' rights issue. Where in Michigan, we had Judge George Stee in Detroit, and he ruled in favor of Obamacare's penalty provision, forcing people to buy insurance, and he says it was not an unconstitutional tax. So because the government's been arguing that it's the Commerce Clause, and if it's not the Commerce Clause, it comes under the taxing authority of Congress.
Well, I understand that Congress has the ultimate decision on taxing. They can pretty much tax, and that's clearly allowed. So when you say that it's a tax or it's a Commerce Clause, how was the bill actually written, and how was it, sold to the Senate and sold to the Congress? What was this clause really defined as?
Well, it kind of depends on which U.S. district judge you're talking to. Now, the U.S. district judge Roger Vinson in Florida said that the rule violates the Commerce Clause, and it's not even a close call. The power to impose that individual man seeks to harness is simply without prior precedents. Never happened in this country under this Constitution. And he said something that's based solely on citizenship and being alive crosses the line to the outermost bounds of federal power. In other words, the federals never have gone and impeded state power to individual power, taken that much power before ever. So he's saying the Commerce Clause doesn't cover this. Okay, and then when he came to the tax, he said he absolutely rejected the claim that it was a tax because there's clear, important, and well-established difference between commerce and tax. And he says if you look at the examination of the plain language of the bill, there's no indication that Congress intended to exercise its taxing authority. And he said for the government lawyers to turn around and say, well, if we lost at commerce, let's go for tax. He says that's an Alice in Wonderland tack of claiming Congress meant something else.
Well, Mark, before you go any further, first of all, the controversy here is how do the states even have standing to bring these lawsuits in federal court? Because you have to have standing to bring a case, and the health care program isn't really being implemented yet. So how did they have standing this far in advance of the implementation?
Well, they've gotten through the original motions to dismiss. So they've all been found to have standing, and it's that they're saying there's an imminent harm, that someone is going to be fined when these things move forward. In Virginia, where they actually passed a law prohibiting people from being forced to buy insurance, Judge Henry Hudson said the federal government under the Commerce Clause never regulated inactivity before, right? And so he's saying if you can have people do this, you can like order them to eat asparagus, you can order them to buy a car. He says the federal government now has boundless powers to tell anybody to do anything.
Hey, Thomas, are you afraid of being ordered to eat asparagus and broccoli and, with your meal every night?
That's going to be very interesting.
I don't see.
And you diet for America.
Well, Mark, I have to bring this up because are the states suing on the behalf of the individuals of the state? Or are they suing on behalf of the government? Because I know there's so many different terms and conditions within the health care plan.
Well, the state attorney generals are saying this is invading state powers. Okay, and so but then the federal government's coming back and saying, well, the Virginia state solicitor, which is the lawyer for the state of Virginia, is saying, this will collapse federalism where you have separate states within a federal system and create national police power. Now, the government argues that the appearance of inactivity is just illusion. They're arguing that sooner or later, everybody ends up in an emergency ward, and so sooner or later, someone's got to pay that bill. So the fact that you're not going to the emergency ward today, eventually you'll have that activity. So that was their argument there. And they said it's not a police power because that's involved with commerce because it's who's paying a bill.
Whoa, hang on, Mark.
That's the government's position in Virginia.
Hang on. Now, So you're saying that the government's arguing
The
that
federal government.
someday somebody will go to a hospital,
And then a debt will be rung up,
and
someone
so
will
how
have to
does
pay
that
for it.
fall under the Commerce Clause, though?
Well, the judge really didn't.
Well, let's talk about the judge in Detroit that actually ruled in favor. And how did they say that effect of somebody going to a hospital and then potentially entering the stream
Well,
of
that's
commerce?
a different case. That's
what I'm trying to understand here.
When Michigan, he just said it's a tax. It's under the taxing authority, and no other judge agreed with taxing authority.
Well, where in the bill does it say this is a tax?
Well, the judge, like I said, it depends on which judge you're talking to.
Okay.
But going back to Virginia, when we talk about tax, the judge said, well, the president vehemently denied that this was a tax when he was selling the bill. And he said, was the president trying to deceive everybody? And the government came back and said this. When the president said this was not a tax, he was only conveying that it was not a tax increase. He was never saying it wasn't a tax. So
well,
that's the government's position.
Hang on. I don't believe the president was deceiving everyone. There may be some extremist views.
No, he was
that. I don't
conveying
believe
that it wasn't an increase. That's what
Okay.
he's saying.
Well, okay. So is there a difference between what Virginia's judge is finding and what a Florida judge is finding as far as the standing and the ultimate decision of how this case can go forward?
Well, I think that Virginia goes a lot further because Virginia has a law, so they have a stronger case.
And that's the 10th Amendment you brought up.
But Florida has 20 states went to Florida, right? So there's a mixed bag there. But really what's going to happen, this is going to end up at the Supreme Court. No matter which federal judge in which state rules what, it's going to end up at the Supreme Court. And people who are looking at the legal analysis think that in the end, most likely, the federal government's going to win at the Supreme Court.
But aren't we already establishing a conflict in rulings when you have one judge saying that it's allowable, one judge or two judges are saying it's not allowable for two different reasons? Aren't we developing a total conflict in how this is going to go forward?
Well, it gets even more complicated than that because the state solicitor in Virginia is going for for injunctive relief and trying to stop it happening in Virginia. And then some pundits are saying, well, okay, if Virginia won't allow the federal system in, then perhaps the federal government will tax or penalize every single citizen of Virginia $2,000, every man, woman, and child, in order to compensate for the fact that Virginia won't let the system in. So it gets kind of interesting when you go there. But I think what it's going to happen, it's going to go to the Supreme Court, and there's going to be consideration of what the lower courts came up with. And I think, as far as drawing out the issues. But right now, these I think are the main three district courts. It's a major constitutional case, I think as big as anything, because the Commerce Clause has been stretched very far to give federal power. And if it can go any further, there may not be much state power.
Well, you know that the Commerce Clause has been expanded greatly.
Oh, yeah.
And the issue with this one is whether or not, in fact, the Commerce Clause will control everyone's personal health and how they get treatment. But it seems as though that there's so many conflicts, and there's still another 24 states that are saying, hey, wait a minute, they're not on board yet. So how are they approaching that?
Well, Judge Henry Hudson in Virginia addressed this issue, and he says it's not really a matter of health. It's a matter of federal power. And if the Commerce Clause can be used for federals to go into the states and start mandating behavior, there's really no limit to what the feds can mandate. And so they can make you buy something, they can make you do something. Essentially, there is no more private property.
Okay, well, I will tell you right now, Mark, this subject, we have to come back to this, and we have to watch how this process is going. The whole fact that the Commerce Clause seems to be expanded, that we have one issue, just leads us to one thing. It's been a wonderful evening. Thomas, thank you for coming. Mark, thank you again.